there are things that we see families do or not do that do cause a potential disqualification for Joey's public benefits. And so I just kind of want to highlight some of these things so that you know you need to do something if you're falling into one of these categories. The first thing I want to mention is a 529 plan or an UTMA or a custodial account or minor's custody account, something like that. As you create those for your minor children and as they start to get older, eventually it becomes a resource of theirs. And if an asset is a resource of Joey's, then it can potentially be used to disqualify Joey from public benefits. So I wanted you to be aware that even those, if you're wanting to accumulate assets in Joey's name, I would either tell people, hey, don't write Joey the gift, just write it to us and we'll hold it for you. But if you're going to want to accumulate money for Joey, then it's probably better to do it either in a standalone special needs trust or into an ABLE account, which, has the ability to save some money for Joey and not disqualify him up to a cap of $100,000. The next thing is an unstructured beneficiary designation. So if you've ever had a job and you went and you did orientation at your job and you started filling out all the forms that you did when you started, they might say, do you want to participate in the 401k, or do you want to participate in our group life insurance, whatever, or you might have your own IRA, or you might have your own life insurance that you've bought. All these things usually have beneficiary designation. And then most people, if they're not thinking about it, they're just going to write my spouse as the primary beneficiary, and then they're going to write your children's names, Emily and Joey. Well, that's a problem, because as soon as you pass away and Joey gets it, it's going to disqualify him from public benefits. That's the pitfall I'm referencing. The pitfall means, is Joey going to receive some money directly? Is there a situation where Joey's going to have an accountable resource for public benefit eligibility? And the answer is yes, based on who dies when. That's what you want to avoid. So I want you to go back and look at your beneficiary designations and make sure you didn't name Joey individually. What you need to do is name Joey Special Needs Trust. That way it's still there for Joey. You've accomplished what you're wanting to accomplish, but now you're not going to disqualify him from public benefits. That's the same for insurance and retirement plans as well. Those are just more specific to those assets. Same thing. Just look at those beneficiary designations. Excuse me. Another one that I see is a big problem, in my opinion, it's probably one of my pet peeves, is mom and dad are going to disinherit Joey because he's not allowed to have any assets, and just leave everything to Emily and then hope that Emily will take care of Joey. That's a major problem, because Emily has her own life and things could go wrong in Emily's life. She could get divorced. She could get in a lawsuit. All that money is subject to that exposure. And I don't want that to impact Joey. Instead, leave it in a special needs trust and name Emily as the trustee of that special needs trust. That would take care of that problem. So don't disinherit Joey. That's not a problem. No planning at all, we talked about. The state you live in has written in the state plan for you. And it says half of it goes to your surviving spouse and half of it goes to your kids. So again, that's that moment of issue, because half your kids, that means some of it's going to Joey. And then the last thing we also talked about, which is navigating gifts or inheritances from other family members. And that's where we come into that play with that standalone special needs trust. So I really wanted to make sure you see these right there and you go home and you investigate what your circumstance is based on these things, because I see it way too often where Joey gets disqualified from public benefits because of one of these things. Too many times. And it is it's very unfortunate when it can be very easily avoided. by some proactive planning. So I'm going to stop there, and now I'm going to open up the remaining time to just questions, because that really was the covered part of the topic of estate planning. And I want to thank all of you for being here and listening. I will end. I unfortunately, as I mentioned, or Sandy had mentioned, I am leaving. I have to be somewhere, so I have to leave now. But Josh, my law partner, is here, and he has been doing this with me forever. So he can answer your questions if you have any. The last thing I'm going to say is, and I've been doing it for, I think, 17 or 18 years for anyone that comes to these workshops. We offer as a complimentary service, it means you don't have, there's nothing to pay, a one-on-one meeting with you to navigate your estate planning and special needs planning as specific as we can be for you and your family. And it's just meant to be able to educate you. It does not mean anything beyond that. It doesn't mean you got to work with us. It doesn't mean you got to hire us. It doesn't matter to us. The education is what matters the most. And all you have to do is call our office. I'm sure Sandy and Brianna can get you information to get a hold of us, me or Josh, and we'll sit down or we'll get on a virtual Teams call, whatever the thing is, and you will learn so much about your family and the things and opportunities that they're there for. And I get that gets taken advantage of a lot by the people that come to these workshops. It's awesome because I see it in their faces. They got a plan. They know what to possibly do. And then it's up to you what you want to do from there. So I just wanted to throw that last thing out for all of you, that it's there. All you have to do is essentially call our office and reference that you came to this workshop, and it's awesome education. So
yeah, we really appreciate you doing that for the family.
Yeah,
really,
absolutely.
really. That's a
I
wonderful.
appreciate you letting me do this. Thank you, Sandy. And I'm going to leave it to Josh from here.
Thank you. Thanks, Josh, for being here too. And I think you can see a few of the questions that we have if you want
Yeah,
to take
I
a
see them
stab
right
at
here.
them.
So the first question, Vivek kind of referenced what to do, but what's the next step after the presentation tonight? And Sandy and Brianne will share Vivek's contact information. They can share my contact information, but basically just give us a call. We'll set up that consultation to where you can ask any questions you have. What will you need to bring to the meeting, or what, to that initial consultation? It's honestly just a pretty good understanding of your family situation. When we're talking about trust, one of the biggest parts of the trust is funding the trust and making sure that everything funnels the way you need it to go. So not only a pretty good understanding of family dynamics, but also sort of just a high level view of like what your asset makeup is. Do you have a house? Do you have 401ks, life insurance? And we'll be able to pull that and extract that from you during that meeting. So you really don't need to bring anything with you. Just a good understanding of the family. How many meetings does it typically take with an attorney to get the special needs trust finalized and ready to go? I can only answer that for ourselves, for how we operate. From that initial one-on-one meeting, we're able to basically get all the information we need from you to where if you're going to move forward with us and work with us to get it done, you're going to have that initial meeting. We will take that information, prepare the documents, prepare the estate plan, and then we're signing the next time we meet. So typically, at most, it'll take 2 meetings. Okay. Next question is, at the end of the meeting, will they give me a cost based on my situation? Can you pay that fee over time? Okay, so we do flat fee our estate planning services, and so that includes the special needs trust preparation. So at the end of the meeting, you will know exactly what it will cost. And then, typically we do like to be paid in one payment, but we certainly understand everybody's family situation is different. And we are more than happy to work with each individual family to make sure that they get the services that they need. So yeah, if somebody needed to make multiple payments over time, we've done it in the past and we do it quite often. What if I set up a special needs trust in Missouri but retired to another state? How does that affect the plan? So each special needs trust and each estate plan for that matter is sort of state specific. Now, the government benefits we're talking about, they are federal benefits just governed by the individual states. So if you set up a trust in Missouri, the good thing is if it's valid in Missouri, it will be valid in every other state. So you don't necessarily have to change it. One thing that you may want to change is like the governing law of it. But if you never did it and you retired and you just let it be, it's going to be just fine. There's no worry that it will no longer be counted as a valid special needs trust. What if my loved one moves to another state for better services, but the trust was set up in Missouri? Same answer, valid in Missouri. The trust will be valid everywhere. Next question. Do we help in writing just a special needs trust, or does it also include my non-disabled? Yeah. So when we sit down to talk about estate planning, the first thing we talk about is obviously the special needs component, but you also would more than likely set up what we consider to be a foundational estate plan. And that foundational estate plan would basically include powers of attorney for mom and dad or the caregivers, as well as if you're doing this trust, it's going to include all of your children with just that special needs component to make sure that whatever their inheritance is doesn't disqualify or impact their eligibility for public benefits. So the non-disabled child would definitely be included as part of that plan. Do you review existing trusts? And if you recommend changes, do you write new trusts or amend the current trust? We absolutely review existing trusts, and we also offer that free of charge. So if you have an existing estate plan, one thing we might ask that you do before that meeting is send it over to us, so that way we can come prepared when we do meet and we're not taking up any more of your time. But we will review it. If it is a revocable trust, and the changes we're going to make aren't too significant, we will probably do an amendment. But again, if we're changing the whole structure of it, we will probably restate it, which is just a full amendment of the entire trust. All right. Do we see families tend to leave more to the child with a disability versus their non-disabled children? All right. So there is no right or wrong answer to this. It fully depends on the earning potential of all the kids. Now, obviously, the child with a disability likely, more often than not, has a lower likelihood of earning a living and an income to support themselves. And so we not oftentimes, but we do see that child receive more as an inheritance, but it's fully dependent on how we're funding these trusts, right? If you have a life insurance policy, maybe there's enough for everybody to go around. They're also going to receive public benefits, whether that's SSI and Medicaid. And once you retire or pass away, they can start drawing off of your Medicare, Social Security, SSDI. So there are other benefits that they will receive that your other children won't receive. And so it's not always a clear-cut answer. Do you leave more to the disabled child and less to the others? It's just purely on what their earning potential is or how you want to provide for them. If you change the existing trust significantly, how do you void out the original? Okay, so when we're talking revocable trusts, you can either do an amendment, which is like I'm going to go in there and change a couple articles. I might change the trustees. I might change, I might add the special needs component, whatever it is. So if you're just doing a simple amendment, we're not voiding anything out. If we're doing a much larger amendment called a restatement, again, we're not voiding out the original trust. The name of it stays the same. The date that you signed it stays the same. So we don't have to retitle any assets, but we restate the trust in its entirety to where this new document, this new restated trust, is the document you bring and you give to the bank, you give to whomever may request a copy of it, but we don't void out the original. You just have a restated version of it. And then what I will say is anybody you gave the original trust to, you have to give them the restated copy so that way everybody's working off the same document. All right, what are the most common issues you find when reviewing special needs trust done elsewhere that you have to correct and amend? Something we typically see, you might see more from attorneys who do estate planning but maybe don't specialize in special needs planning, is the special needs trust will be for the benefit of multiple individuals. So one of the rules for special needs planning is that there's the sole benefit rule. Means that if I create a special needs trust for Joey, I cannot have that special needs trust be for Joey's benefit plus, I think Bhavik used Emily, right? So it can't be for both Joey and Emily. It's got to be solely for Joey. The other thing we see is there will be third-party special needs trusts that have Medicaid payback provisions. We want to make sure that if it's a third-party trust, meaning mom, dad, grandma, grandpa, some guardian is setting this trust up for their child, that we want to make sure that nowhere in there does it reference Medicaid or any payback provision. And so if that is in there, we would absolutely remove it. But it's so really the most common we see is it violates the sole benefit rule. It has a Medicaid payback provision, or it allows the beneficiary to request funds and have those funds go directly to them, which would also impact the public benefit eligibility. Next question is, if you set up the special needs trust when the parents were married, but then they divorced, how do you handle that? And so it really depends on what type of special needs trust this is. Bhavik mentioned a testamentary special needs trust, as well as a standalone special needs trust. If it's a standalone special needs trust and both parents are co-trustees, then we're really talking about, are they amicable? Can they get along when they care for Joey? If they're not able to get along, if they can't use this trust jointly to take care of Joey, what we typically recommend doing is each parent set up their own. They can fund it with whatever they want, and then they don't have to interact with each other. If they do get along and they have this standalone special needs trust already created and they're co-trustees, great. You can still be co-trustees while divorced. If you have a joint family trust, and which then creates the special needs trust for Joey, when you go through the divorce, that trust has to be essentially terminated, at which point mom and dad would create their own trust at that point.
Mm-hmm.
I think Bhavik may have alluded to it, but one thing we typically see with divorced parents of a disabled child is if one parent is paying child support to the other, that child support payment is deemed income to the disabled child. And so because it's income to them, it is going to negatively impact their SSI eligibility. And so if you are already divorced, the kid's turning 18, if we want to apply for public benefits, you have to amend that child support order to have that child support funds go into a first party special needs trust. Next question is, how often should you have an attorney review your entire estate plan? We set up a special needs trust 10 years ago. Is it time for a checkup? Absolutely. A lot of special needs planning rules, trust rules have changed, and it may not be like catastrophic, but things may need to be tweaked. And we typically recommend families look at their estate plan every 3 to 5 years, or if there has been like a life event, somebody you've named to be a trustee has passed away, they've aged themselves out, they're no longer able to do it. So really, I think the rule of thumb should be 3 to 5 years, or if something warrants doing that sooner. It says, you mentioned a life event. Would the individual moving into a group home warrant that? No. The reason no, when I say life event, it's more so, I've named my mom and dad, my child's grandparents to be the backup trustees, right? If one of them passes away, they're getting older in age, they might not need that responsibility on them, as they're also just trying to take care of themselves. So life event, somebody passes away, somebody becomes incapacitated themselves. I've had a falling out with a friend or a relative to where I no longer want them in my documents. That's more of the life event I'm talking about. If the child moves into a group home, they're still eligible to receive their public benefits. They're still eligible to be the beneficiary of that special needs trust. So, I mean, first off, that's great that they were able to leave, the family home and move into a group home, but that wouldn't warrant you having to update your estate plan. If they move into a group home, do we tell the staff about that trust? It depends on how. I think it depends on how they're going to pay for that living arrangement. If because the special needs trust is there to supplement public benefits, if they are receiving SSI, which is only to be used for food and shelter, well, while we can tell them that the trust exists, we need to make sure that the SSI funds are depleted before we ever use this trust to pay for the housing. I think oftentimes when you apply to go into a group home, they ask you for their assets. And so you may disclose it at that time, but it should, when you're paying for it, this should not be the first resource that's used. You should definitely deplete the SSI first. How exactly are funds paid out of the trust? The trustee would pay for the vacation or camp that Bhavik mentioned earlier. Group home staff would tell the trustee about the camp to ensure that the camp gets paid. Because it is a special needs trust and because the funds cannot go from the trust to the beneficiary, they must go from the trust to the third party. So in your example, the group home, if they're like helping set up the camp or the camps run through that program, basically they would submit the invoice to the trustee. The trustee would then pay it directly to that organization. Another example is if they had to go to the dentist for dental work. The trustee would get the bill and they would pay that directly to the dental office. Whatever funds come from the trust just go directly to the third party, okay? Never to the individual beneficiary.
So this is something that I was thinking about when we're thinking about, we don't want the funds to go to the participant, right? So we say participant here, the individual with special needs. I recently learned about the Secure Act, which, and so again, people can Google it, but it is relevant to Missouri because it's U.S. It's a U.S. law. So let's say that the trust has these IRAs in them and the parents are older and they've been withdrawing that money and then they pass away. Is there a way to protect, again, when people Google it, they'll understand what I'm saying, but is there a way to protect that individual from having to take those required withdrawals?
Yeah. So by way of background, the Secure Act essentially says that a beneficiary, other than a spouse or actually disabled individual, they have 10 years in which to deplete an inherited IRA, 401k, any other tax-deferred retirement account. The purpose behind that is so that there wasn't this generational wealth that just passed generation to generation, just basically taken off the top layer of income. The government wanted to make sure that these accounts were being received by the actual beneficiary.
And
so,
taxes were being paid. I think that's it too.
Absolutely. Yeah. And so the way you get around that is, so if it's my child who's the participant, I would name their special needs trust as the beneficiary
of those IRA funds. Interesting.
Yep. The account still has to be depleted in that 10-year time frame. Mm-hmm. But instead of the money going directly to the individual, it's going to be held in that trust, and then the trustee can continue to monitor and manage the funds just like any other asset. So still gets paid out. If you don't name the trust as the beneficiary, you just have the Joey or the participant named, they can basically take it out based off their life expectancy. Okay, so we're not confined to the 10 years.
Okay.
But that's still income, that's still a resource, and it's still going to disqualify or greatly impact their SSI eligibility
Right.
and Medicaid eligibility.
Right. I feel like a lot of our, our caregivers who are getting older, their IRAs are what they do put that in their trust. Absolutely.
Yep.
Right. And so it's something I didn't know that the kind of exclusion or the changes for someone who has a disability. So that's good to know.
Yeah. But the only difference is you can, instead of having that 10-year,
Right.
you're confined to the 10 years, you can do the life expectancy, but it's still going to greatly impact the benefits.
It
And
is.
so you would want to name the special needs trust as the beneficiary of the retirement account.
So I want to thank everybody for joining the webinar tonight. But we do appreciate both of you very much and all the things you do for our families. We really do.
Happy to do it. Very happy to do it.
Thank you.